The court's understanding of the relevance of economic testimony, I think, really were highlighted by the testimony that were offered in the USA versus Penn case involving broiler chicken suppliers, and in the USA versus DaVita case, where it was the first criminal case that the alleging no poach agreements among certain executives in the healthcare field. In both of these cases, the Justice Department actually decided not to offer any economic testimony affirmatively or in a rebuttal capacity. But the defense, basically, their sole witness in these cases was an economist who took on really the test and the question of whether an allegation of the kind that was alleged by the government exists at all by actually looking at economic evidence, both the qualitative evidence related to the industry background and the market structures, and whether given those factors, the types of patterns that the government was alleging was related to price fixing or no poach was actually that or something else, as well as looking at quantitative evidence of benchmarking analysis, looking at prices or wages or quantities, or here in this case, movements of employees against industry benchmarks or in the before, during, and after period. And both of these cases ended in an acquittal. In the DaVita case, there was an interesting aspect to the case where the juries were able to ask questions to each witness, and the economic expert in that case received over 50 questions from the jurors, which I think highlighted the fact that they were paying attention. They were actually quite interested in what the economists had to say. And these questions range from whether the firm the witness economist came from had any relationship with the defendant, to very technical questions like p-values and the choice of certain kind of statistics over others. And from my perspective, sitting in the courtroom, I think the economic testimony provided really a clear framework for analyzing the questions that ultimately appeared in the jury instructions approved by Judge Jackson, which highlighted in some ways the need to think about the intent of the actors, as well as whether the alleged agreement had some sort of a suppressive effect on competition in the market.